technical name for enforcing judgments in Scotland is called diligence, and Thomas and I are going to give a very high-level run-through of some of the most commonly used form of diligence we have in Scotland. The first thing to mention when we talk about enforcement methods in Scotland is really the charge for payment. A charge for payment is a prerequisite to some forms of diligence being carried out, such as an earnings arrestment and attachment of goods. We will come on to talk about those shortly. A charge for payment is a formal demand for a sum of money. It specifies the sums due in terms of the decree and also includes a prescribed fee for the cost of serving the charge, as well as typically an amount of interest. The charge for payment is served on the debtor by an officer of the court. In the sheriff court, they're called sheriff officers, and in the court of session, they're called messenger at arms. They're akin to an English law bailiff. The charge for payment can often be an effective enforcement method in and of itself, encouraging a debtor to make payment without further action being taken or to discuss the debt with the creditor and make proposals. The charge for payment allows the debtor 14 days to pay the debt, and if the debtor fails to do so, then the creditor can instruct the sheriff officer or messenger at arms to carry out diligences on their behalf to recover the sums of money. Failure to pay the charge within the 14 days also constitutes apparent insolvency, which can found the basis of a petition for bankruptcy of an individual, or sequestration as we would call it in Scotland, or for the winding up of a company. A charge for payment lasts for a period of 2 years, and once the charge expires, if payment has still not been made, further charges can be served on the debtor. The first form of diligence we are going to talk about are arrestments. Arrestments are used where money or movables belonging to the debtor are held by a third party. The arrestment is served on the third party and prohibits them from transferring the money or movables to the debtor. In most cases, a charge for payment is not required to serve an arrestment. One of the most common forms of arrestment used in Scotland is the bank arrestment. The arrestment is served on the debtor's bank, freezing funds belonging to the debtor. If the debtor does not pay the debt or agree to release the funds are automatically released after a period of 14 weeks. Where individuals are concerned, there's a minimum protected balance, and only sums over that minimum protected balance can be attached. This is to prevent hardship to ensure funds are available for basic living expenses of the debtor and their family. It's important to bear in mind that arrestments are time sensitive, and as a result, they're often speculative in nature. So for example, if I were to serve a bank arrestment today, it would only catch what is in the debtor's bank account today at the time it is served. If the debtor paid £1 million into their account tomorrow, that wouldn't be caught.
Wages arrestments are a special form of arrestment served on an individual's employer and obliges the employer to make a deduction from the debtor's earnings. To carry out a wages arrestment, the creditor needs to first serve a charge for payment on the debtor. The amount of the deduction is determined by a statutory scale, depending on the income and the frequency of the debtor's pay, and this is updated from time to time. For those on very low incomes, there is a level at which no deduction is permitted, and this again is designed to prevent hardship on the debtor. The next type of diligence we want to discuss is attachment. Under an attachment, goods belonging to a debtor are seized with a view to their ultimate sale by auction. The sheriff officer or messenger at arms will prepare an inventory and valuation of the movable property of the debtor, and the attached items may subsequently be auctioned and the proceeds distributed. In the majority of cases, the threat of assets being sold at auction prompts the debtor to pay the debt or to make proposals. Where individuals are concerned, special rules apply. To attach goods inside a debtor's home, special orders must be obtained from the sheriff court and cause must be shown. These orders are called exceptional attachment orders, and as the name implies, they really are exceptional in nature and rarely sought in practice. Where individuals are concerned, there is also a long list of exempt assets which cannot be attached, and again, these are rules designed to prevent hardship to the debtor and their family.
One of the most commonly used and effective forms of diligence used in Scotland is an inhibition. An inhibition is considered as a so-called freezing diligence, as it preserves the debtor's estate. The inhibition is an order prohibiting the debtor from dealing with their heritable property, And that covers not only them transferring or selling their property, but also stops them from burdening the property with standard securities, i.e. mortgages. The inhibition requires to be served on the debtor, and it is then registered in an official register called, funnily enough, the Register of Inhibitions. An inhibition lasts for a period of 5 years and covers all of the debtor's heritable property in Scotland. Unlike a charging order in England and Wales, an inhibition is not a form of security per se, but they are still incredibly useful. If a debtor wants to sell their property or obtain further securities, they will need to have the inhibition discharged, and that invariably means engaging with the creditor, who will no doubt insist on payment. A charge for payment is not required to be served for an inhibition, so this form of diligence can be carried out more quickly.